Good morning, everyone. I'd first like to introduce us this morning. I'm Hannah Swindle, a legal director in our Employment, Labour and Equalities team here at Gowling WLG, and I'm joined by Jasmine Coyne, a senior associate in the team. So this live webinar this morning is designed to help you deal with some of the frequent issues that can arise on a TUPE outsourcing or insourcing, or in some cases also on a business transfer. And we're going to be looking at how they affect both incoming and outgoing employers. We'll identify some common pitfalls and liabilities, how you can avoid them, and give you some practical tips on how to manage a smooth transfer. And we're intending this webinar to be relevant for those either on the operational or legal side of a TUPE transfer. So just as a quick recap of our agenda here today, we're going to be looking at timelines, information requirements and pitfalls and how to avoid some common ones there, solving assignment issues, dealing with employees on enhanced terms when they come across to you, and managing performance issues with incoming employees. So to start us off, the first topic we wanted to look at is planning and timetabling for a TUPE transfer. It's really important to make sure that you start planning at an early stage to ensure a smooth transfer, whether that's a transfer in or out of staff. There may be a number of different teams involved in a transfer from across the company, might have HR, legal, procurement, the contracts team. So trying to get a good cross-business dialogue started as soon as possible and making sure everyone is joined up is really essential. You might also need to coordinate with a subcontractor if they're going to be affected by any transfer. So what should you be thinking about as either an incoming or outgoing employer, and what are some of the main timelines you need to factor in? First of all, I want to mention gathering employee information. Jasmine is going to cover in more detail the obligations for the outgoing employer to gather and provide employee information about the transferring employees in a moment. But this should be put on the list as one of the first things to factor in. The outgoing employer needs sufficient time during the preparation process to be able to gather everything together. There are timing deadlines to provide information to either the incoming employer or the client of a service under both TUPE and also potentially under an existing services agreement. And if you don't comply with that, you could face penalties. So as a practical point, where there are a greater number of transferring employees or you need to coordinate with subcontractors because you're contractually responsible for ensuring that information is provided as well, the exercise is, of course, likely to take longer. As an incoming employer, you will want to press for full information at as early a stage as possible so that you can start to look at who's going to be coming across. You're going to need this information to know whether you'll be able to staff the services from day one, what roles are people carrying out, or whether you're going to need to start recruiting. And also, of course, you're going to want to check the terms that the employees are entitled to. TUPE requires you to maintain current terms and conditions for transferring employees, but you might not be able to do that for everything. For example, you might have to work out how to replicate some insurance benefits or company-specific benefits the employees currently have. You'll also need to know and to let the outgoing employer know if you're proposing any changes to working conditions or measures so that they can be included in the consultation process. So this leads me neatly onto the next element to consider in your timetable, the information and consultation process. Both the outgoing and the incoming employers have obligations under TUPE in relation to informing and consulting the staff, and it's risky if you get this wrong. Maximum compensation is up to 13 weeks gross pay or a quarter of the wage bill. There's no set time period for consultation. It just must be long enough to be effective, which means that it's got to be carried out with a view to reaching agreement, and the employer must be able to show that it's considered any issues raised by the representatives or the employees. So when working out your timeline, you'll need to consider how long this process is likely to take. You'll need to consider if you need to elect employee representatives as a starting point. You might already have them, or you might have trade union reps. Otherwise, you may not need to elect reps for a process, and they're no longer a requirement where you have fewer than 10 employees transferring, or you're a smaller employee overall. If the employer wants to or needs to elect representatives, especially because it's sometimes helpful to give employees a route to ask anonymous questions, you'll need to allow enough time in the process to have an election before the information and consultation procedure can start properly. Practical and logistical issues will also affect the timeframe for the consultation. Where are your staff based? Are they all on one site or are they spread around? How many will need to be spoken to? Is it a holiday period? If there are lots out of the business, you need to factor in time for those absences and how you're going to speak to all those people. What changes are the incoming employer proposing? And are there lots of complex issues at play? All of these sorts of factors may make it difficult to carry out a genuine and effective consultation and mean that you need to allot a bit more time to it. And remember, even if there are no measures or no proposed changes, case law says that you should allow time for voluntary consultation in any event. And keeping the employees informed, making sure they know what's going on is going to be helpful and going to help ensure a smooth transfer anyway. The information and consultation process is primarily the outgoing employer's responsibility, but the incoming employer also has obligations as well. The obligation to provide measures that I've mentioned, but also as an incoming employer, you want to keep an eye on what's going on. Liability for a successful claim is joint and several, so it could still end up being your problem if the outgoing employer doesn't do it properly. And although you'll usually expect to have contractual indemnities underwriting this risk, there are other reasons why carrying out proper consultation is important. You'll want to make sure that a sensible process has been carried out for the staff. Keeping them informed and updated, as I said, will help ensure a smooth transfer and help bring about a positive start to the new employment relationship. Often, as an incoming employer, you'll also want to factor in enough time to be able to take part in that consultation process. It's good to be able to get in front of the employees and start winning hearts and minds, especially where you're proposing more significant measures. If you're able to explain the rationale for those and answer questions, it can help the process go more smoothly. And don't forget, as an incoming employer, that you might also have to factor in an information and consultation process with your own employees. This is going to be required if they'll be affected by the transfer in some way. It's not just an obligation for the transferring employees. Then finally, as a very last point to flag on consultation, it's open to employers to start a collective redundancy process pre-transfer if one's needed, and that could be either a 30 or 45-day process. If so, you'll need to pay attention to the timing of that process, or you might then have to finalise it post-transfer. We haven't got time to cover that scenario in any more detail today, but we have covered it in previous webinars available on our website if that's of interest. So the third point I want to cover off when we're talking about timetabling is the date of the transfer. Often it's going to be really obvious when the transfer is going to take place, but you need to be careful not to be caught out where the situation is slightly more complicated. There may be a ramp up or a longer transition period for the transfer of the services where you've got an incoming supplier, rather than everything transferring across in one go. And that can make it difficult to work out when employees should be transferring. Sometimes there might be a tipping point where it makes sense for the employees to transfer, or it may be more sensible for the employees to transfer across in tranches, especially where the outgoing employer still has responsibilities to satisfy for the customer up to the ultimate termination date. There may be another factor triggering the transfer, such as an assignment of a lease in a property transaction. These external factors can quite often become delayed, or on the flip side, they can happen more quickly than expected. So this is especially where the internal teams within the business need to keep everyone informed to avoid unexpected employee consequences. Of course, it's essential to keep employees up to date. You need to reduce uncertainty in any process, but also make sure that a trigger is not triggered accidentally when other teams are not ready. If you don't keep HR and operations updated by the property teams or legal, this could result in a failure to carry out a proper information and consultation process before that transfer takes place, and could lead to potential claims as well as practical workforce issues if the employees are not in the right place to deliver the services. So what are the key takeaways here? First of all, goes without saying, start the planning process in good time before the intended transfer date. This will give you the best chance of ensuring that everything happens smoothly. And then make sure that all of the relevant departments, HR, commercial, operations, legal, ensure they're all communicating and are joined up, and keep each other updated when you're dealing with a transfer, especially when perhaps they're situated on different sites. Thank you. Now I'll pass over to Jasmine.
Thank you, Hannah, and good morning, everyone. Hopefully, as you know, TUPE stands for the Transfer Undertakings and Protection of Employment Regulations. And it's protection of employment that's key and that TUPE seeks to do in a number of ways, such as dictating that employees will transfer on their existing terms and conditions. When an incoming employer is getting ready to accept new employees, they will want to make sure that there'll be no surprises and will need information about those employees before they transfer. In this section, we're going to look at how you go about getting the information that you need, whether you're the incoming contractor or the client when insourcing or for potential contractors as part of a tender process. Regulation 11 of TUPE sets out the obligation on the outgoing employer to provide employee liability information to the incoming employer to help them understand what they will inherit in terms of number of people, the profile of the people, and what basic terms and conditions they're on. I'm not going to read out all the particular categories of information on the slide, but they're there and they're set out in detail in Regulation 11 of TUPE. However, employee liability information is pretty limited in how helpful it is to new or potential providers. Yes, you get the basic contract terms and whether there are any grievances or claims to note, but ELI does not cover whether employees have enhanced redundancy protection, and if the incoming employer is looking to reduce the headcount post-transfer, that type of information could be very significant and something that the incoming employer would need to factor into their pricing, for example, in a tender situation. Also, ELI does not cover, for example, if employees have valid restrictive covenants in place. It doesn't cover non-contractual benefits or full information about pensions or administrative information that the incoming employer will ultimately need to honour post-transfer. So while it is a fallback position, the information provided under Regulation 11 often doesn't go wide enough to cover other commercial issues. Additionally, as well as the limited content provided under Regulation 11, ELI is also only required to be sent 28 days before a transfer. Again, this is unlikely to suit the tender process where contractors are likely to have to bid for work well before 28 days before a proposed transfer. If relying solely on the ELI provisions and the 28-day timing stipulated in Regulation 11, contractors will be quoting for work whilst having no information about potential incoming employees, which will necessarily have an impact on the quotes provided. Put together, this is why the parties often agree to provide information that goes beyond ELI to provide more information and on a commercially useful timeframe. So parties often stipulate as part of a service provision contract that certain information will be provided by the incumbent provider at a certain time. And these contractual obligations will be wider and more onerous than what's required under TUPE. And usually the contract will require that information is given at least at the tender stage, or for example, at a specified time before the termination of the agreement, for example, 6 months before the termination of the agreement. And there are also often requirements to provide information on termination as well. As well as providing the required information under the service contract, the current provider will also need to make sure it checks and complies with any other ongoing notification requirements and complies with any restrictions on changes to the terms and numbers in the workforce providing that particular service. For example, it's typical that the incumbent provider cannot make significant changes to the workforce or their terms and conditions in the period approaching the end of the contract. Again, likely between the tender stage or from a specified date up until the end of the contract. These contractual restrictions are known as anti-sabotage clauses, which prevent the outgoing employer from effectively sabotaging the new provider or preventing a new provider from bidding for work. However, you should be aware that although these protections might be in the contract, there's always going to be a practical problem around having sufficient transparency to enforce these anti-sabotage clauses, because in order to know whether the incumbent contractor is making those changes to the workforce near termination of the contract, you would need to have a point of reference as to what the workforce position was originally, which practically you may not have. So this lack of transparency is just something to be aware of when you're trying to pin down details about the workforce and when you're requesting their information. What happens though if the current contractor doesn't want to provide the employee information about the workforce? One of the issues that tends to arise in this situation is, for instance, where a contractor is providing services to a client and a new contractor is likely to come in. And it's quite common in this instance to see some resistance from the current provider to provide some of the information asked for. And the starting point should be to try and understand why the current provider won't give the information. This could be a practical issue. For example, if the outgoing employer doesn't have easy access to the relevant information. And this reflects the importance of information gathering and keeping it up to date by the HR team. Sometimes the incumbent contractor simply doesn't want to be helpful because they don't want to lose the contract. And often there are concerns raised around data protection. We won't dive into data protection fully, but I do want to touch upon it briefly to flag the headline points that businesses need to consider when providing and requesting employee information as part of a TUPE transfer. Because if an outgoing employer is raising GDPR as a concern, clients and incoming providers need to be able to, if the situation calls for it, trying to persuade them otherwise. So GDPR doesn't stop us from sharing information in a TUPE situation, but what it does mean is that we've got to focus our minds more on what information is being shared, why it's being shared, and how we're going to go about doing that. And there are typically three scenarios that we'll likely encounter when it comes to the transfer of personal data in this context. Firstly, there is the giving of the employee liability information in line with Regulation 11 of TUPE. Now, from a GDPR perspective, if you're in ELI territory, the position is for the most part straightforward because providing ELI is a legal requirement under TUPE. So as long as we're providing the right information to the right person in the right timescale, then you've got a lawful basis for providing the information under GDPR. I did say that the position is for the most part straightforward because there is a word of caution to be had here. Although the ELI categories of information are quite limited, outgoing employers will need to check that nothing in the schedule amounts to special category data. This could arise, for example, if the ELI schedule refers to a grievance about race discrimination, or perhaps reveals that the employee is a trade union member because of details provided in the schedule in relation to a related claim. If that's the case, then it will be necessary to identify an Article 9 condition, as well as relying on the primary ground for processing, and they're quite narrow. So be careful with that, and we'd recommend that you'd seek further advice if that's the case. But as I said, in most cases, you should be able to push back should the provider raise GDPR as a concern if the information is solely ELI and the timing is right. The second scenario is where either there's an agreed process or contractual requirements to provide information, which goes beyond the scope of ELI under Regulation 11. As we've discussed, contractual arrangements to provide information usually go beyond ELI and are much earlier. And the third scenario where you might be providing information or receiving information is where parties request detailed employee information when the transfer is about to happen, such as a handover of detailed payroll, HR information and personnel files. These last two scenarios are clearly outside the scope of ELI. So if a provider refuses to share information because of GDPR, the most common argument to make is that there is another lawful basis for sharing the data, such as there being a legitimate interest. Legitimate interest is the most common basis for processing data in this context, and in order to rely on that ground, it's important to firstly identify the legitimate interest and then also work out why the data is necessary for the purposes of that legitimate interest. And then you need to carry out a balancing test to balance the relevant party's interests against the interest of the data subject before deciding that the balance of interest justifies the disclosure of information. Where possible, though, in particular, where you're required to share data months in advance of a transfer as part of a contractual requirement, the easier way to comply with GDPR is to convince the incumbent provider to provide information on an anonymised basis, because at that stage, the information being shared is then not personal data. And this is often a useful option to advance when the incumbent provider is using GDPR as an excuse not to share employee information. So what can you do if, despite your best efforts, the outgoing employer will not share the required information? Of course, from the point of view of the client, the first thing to check is the contract between the client and the current provider and consider what requirements there are about provision of information by the current contractor and what the requirements are about timing and when it must be provided. As a takeaway, I want to highlight the importance of always dealing with the end of the contract when entering into an outsourcing agreement. If the exit clauses and practicalities aren't dealt with properly, the client can end up in a tricky position. For example, in the absence of a clause requiring information to be given, that can significantly impact on the tender process, the price new providers might be prepared to take the contract on for, or the client may have to take on no risks, such as by giving an indemnity to the incoming employer if certain assumptions aren't true, or if the risk is greater than anticipated because not enough information was given early enough to properly assess a risk. Practically, though, if you are in a position where you do not have a contractual right to receive information, there's still no harm in asking for it. Whether the contract is well drafted and deals with the requirements and process for giving information, or you simply ask for it, there can still be pushback from the outgoing employer. And if the outgoing employer doesn't want to or can't give the right information, it may be in breach of contract. However, at that point, as there's no loss, you can't really pursue it. So the client and incoming provider will need to think and agree about how they're going to deal with that breach. Practical steps that the client could, for instance, take could be to opt to withhold payment for services from the current contractor. You would need to consider, of course, the risk of any impact on provision of service. Or the client could consider using other levers in the contract or in their relationship with the contractor to persuade the current contractor to assist. For instance, the client might remind the contractor that service provision is often circular and the contractor could be on the other end of a service provision change elsewhere in the market involving the same client. And the client could also hint that cooperation might put them in good favour with that client for future work or for a current tender. Ultimately, though, if contractors are refusing to provide information, you'll need to have consider what you have to negotiate with, whether that's based on the contract or the relationship you have with them, and then just try to use it. I'll now hand you back to Hannah.
Thank you, Jasmine. So the next area we wanted to look at is who's in scope to transfer under TUPE and how you make sure that these are the right people. It goes without saying that it's better for everyone involved if there's as much certainty about who's going to make up the transferring employees as possible. I'm going to talk about some of the possible issues that can crop up for both the incoming and outgoing employers. So first of all, who's going to be assigned to either a business undertaking or a service? I'm not intending to cover assignment in any great detail here this morning, but as a very quick reminder, I just wanted to flag that there's no clear way set out in the TUPE regulations to work this out. It just talks about being assigned to activities or an undertaking other than on a temporary basis. So we have to look at case law to work this out, and that's confirmed that we need to look at all the relevant factors. This will include the nature of the work the employees do, time they spend on the relevant activities or business, what their contract says about their duties, what they actually do, what are their responsibilities in actual fact, and also whether they can be required to work on any other contract. But importantly, it is not just the time spent by an employee on any particular activity, which sometimes can be a common understanding. It can be a useful rule of thumb, and it is quite good to use initially, but that's just to flag up, that's not the only thing that needs to be looked at. And also, when you're looking at assigned employees, don't forget about employees who are out of the business. There might be employees on secondment elsewhere. There may be some on sickness absence or family leave. The employees are still going to be assigned, even if they're not actively engaged in the business or the services at the moment. So don't forget about them, and they need to be included in the transfer and in any consultation. So if we look first at some of the problems might be faced by an outgoing employer, what might you be concerned about? What do you need to keep in mind? So firstly, it's key to work out who has to be in scope to transfer, who's going to be in scope to transfer, and you need to do that in good time before the transfer itself. You might want to retain certain employees because they've got specific skills or because you need them on other client contracts. You might be losing staff who currently work across a number of contracts, and so you'll be left short-staffed if they do transfer. So how are you going to do that? As a first step, firstly, check that TUPE is actually going to apply to them. Are these employees assigned at all? For those who work across more than one contract, this might be particularly relevant. If they're not dedicated to the transferring services, you can remove them from the pool, and that's quite an easy way of dealing with it. But if you do consider that the employees are assigned, then they're going to transfer automatically if nothing else happens. They don't need to agree to the transfer. This, of course, happens by operation of law. So what might you do to try and deal with this? An outgoing employer might try to reassign the staff elsewhere, maybe onto different customer contracts or services, or move them around generally into different parts of the business. This could be done immediately before the transfer or a little time before, but you've also got to be careful. You've still got to be able to deliver those services to a customer up to termination, especially if you've got KPIs to meet. And the supplier also has to be careful not to breach any anti-sabotage restrictions in the contract that we've mentioned. Usually, if there are these provisions in an agreement, there may be a carve-out, so changes can be made with customer consent. But of course, you need to check what these restrictions are and make sure you don't breach them accidentally. Employees are also still going to be in scope to transfer if they're assigned other than on a temporary basis. So if the outgoing employer does make any changes to duties of an employee, they've got to be made on a permanent basis so that you can make sure that they're not still going to be caught by that TUPE transfer. If the employee's contract doesn't allow the employer to change their duties, then you're going to need employee consent to make any of those changes. And it's a good idea in any event to make sure that the employee is, of course, on board with any move to avoid them trying to unpick everything and claim that they should have transferred at a later date. You may want more certainty that an employee is not going to transfer. Employees do have the option to legally choose not to transfer by way of an opt-out. The effect of that opt-out would be to end their contract of employment on the transfer date with no entitlement to notice or redundancy pay. So understandably, the employee is not going to choose to do this without having the certainty of another job to go to. So usually the existing employer would offer the employee new terms and conditions elsewhere in the business, and they'd start immediately following the opt-out. In terms of the process, you'd ask the employee to sign an opt-out letter, and then that would usually attach a new contract of employment as well. You'd send the opt-out to both the outgoing and the incoming employer, and the employee would sign the new contract. This would also give the incoming supplier comfort that the employee is not going to change their mind a little bit later and argue that they should have, in fact, transferred because they've decided to change their mind on that opt-out. And as the new employment terms are going to start immediately, there's no break in service for the employee and they're going to have continuous employment. Ultimately, though, how successfully an outgoing employer is going to be in retaining staff is going to depend on whether the particular employee wants to transfer or not. If they don't want to remain with their existing employer, then this conversation is going to be much more difficult. And as an outgoing employer, it's important to have certainty so you know whether you're going to have to backfill or recruit for new staff to service your other contracts. And finally, there may be a commercial decision made about redundancies that they're going to be made pre-transfer. So not necessarily about retaining staff, but just ensuring that particular employees are not going to transfer across and making sure that connected liabilities are dealt with. As you know, any dismissals made by reason of the transfer itself will be automatically unfair. So if you're making pre-transfer dismissals, that needs to be done under a settlement agreement which protects all parties, both the outgoing and the incoming employer, or employees could potentially still claim against the incoming employer. Often the outgoing employer is going to be giving indemnity protection for claims from employees who are not intended to transfer. So they could end up paying twice under the settlement agreement to whatever they've agreed to pay the employee, and then also under the indemnity if those employees decide to bring claims against the incoming employer. Of course, it's open to the parties to agree commercially how to apportion any costs here. There could be some form of cost sharing. So usually there's going to be an incentive for all parties to prevent unexpected claims from an employee. So now if I turn to look at the incoming employer's side, you're usually going to want a clear list of who's going to transfer as well. Knowing who you're going to get enables an incoming employer to determine whether it's got enough headcount to provide the services from day one. Does it have the key skills or knowledge that it's counting on to be able to provide the services and ensure that smooth transition for the customer? And this is especially important in very technical sectors, or perhaps in, say, a property management context where you want employees who've got good knowledge about a particular building. You might want to ensure that those employees come across as key employees. If they're very important, you could try and add contractual obligations and protections so that the outgoing employer is required to do everything that they can to make sure that they'll transfer. Often it's going to be for the outgoing employer to provide that initial list of transferring employees. Sometimes another party will be able to have some input into this. Possibly the customer of the services might be able to make some representations. But also it might be the case that the incoming employer might not agree with that list put forward by the outgoing employer. They may suspect that the outgoing employer is trying to offload some staff, maybe poor performers or some more expensive employees. Or they might be trying to offload staff that currently work across multiple contracts but would be facing redundancy if they've lost one particular client because they don't then have enough work for them to do. Suggested ways to try to challenge this would first be to ask for more information. In the first instance, as an incoming employer, you'd be asking for this from the customer, or you might be able to have a dialogue with the outgoing employer. You'd ask about the work that the employees are doing, ask for details about the proportion of time that they spend on other contracts, try and obtain some more details about what their contracts of employment say, and also the start date on which they became dedicated to these particular services. If they were moved onto the contract recently from elsewhere in the organisation, it might be possible to argue that they're not permanently assigned. Ideally, it's of course better for the parties to come to an agreement on the list, or for everyone to accept who's been included, because otherwise this is going to lead to uncertainty and potential claims. Having a list of transferring employees is not going to prevent other employees who haven't been included claiming that they should have transferred after the event. So the incoming employer is still going to need some indemnity protection against costs arising from claims from those unexpected transferring employees, or otherwise known as woodwork employees. And protection would often include the costs of making those people redundant after an unexpected transfer. If a claim is brought by any employee, it's going to be up to an employment tribunal to decide whether TUPE applies at the end of the day. If it's found not to apply, then costs of that dismissal would sit with the outgoing employer, but the incoming employer is still going to have that time and cost of having to fight a claim in the first place. So it's better to try and avoid them. In conclusion, having contractual warranties and indemnities do help address certain risks and liabilities, but when you're providing a service, having the right employees in place at the right time is probably the most important thing to ensure that the services can be delivered effectively from day one, in accordance with the contract terms and the client's needs. This way, you can ensure that that service is provided to the customer and avoid any penalties under the contract. So now I'm going to pass back to Jasmine, who's going to talk about how you might deal with a situation where you inherit employees on better terms than your existing employees.
Thank you, Hannah. Yes, that's right. We're going to consider how we deal with the workforce when incoming employees have different terms to the existing workforce and the general considerations that might arise. So as employees will transfer on their existing terms and conditions under TUPE, there can be problems either with the incoming employer, for example, because terms of the incoming employees may be too expensive or can't be replicated going forwards, or problems can arise following the transfer, such as potential claims for equal pay, whereas a legacy of transfers, men and women end up being paid differently. Or there could be issues with employee relations when incoming employees have more favourable terms than the existing workforce. Or there could just be the additional administrative challenge from an HR and management perspective as it becomes necessary to manage a workforce with inconsistent employment terms. So in terms of what transfers into TUPE, this will be all contractual and discretionary / non-contractual terms. And it's important to remember that some terms which were originally intended to be discretionary can become implied into the contract of employment by reason of custom and practice. So it's important to keep that in mind and make inquiries about the employment relationship, as well as relying on the contractual wording. And this distinction between contractual and non-contractual terms is important in the context of TUPE, because TUPE makes it harder for an incoming employer to change terms and conditions of employment where the sole or principal reason for the transfer, before the change, is the transfer. Any change will be void unless the sole or principal reason for the change is an economic, technical, or organisational reason, otherwise known as an ETO reason. And the employee must also agree to the change, or otherwise the terms of the contract must permit a change. But the good news is that the new employer, has got the same rights as the previous employer to make changes if it wants to non-contractual benefits and provisions. So what might the incoming employer do in this situation where the incoming workforce has different terms to the existing workforce? Well, the first thing to consider is whether a TUPE transfer has actually taken place. It seems obvious, and you think you might know, but it's worth double checking that the requirements of a TUPE transfer have been met. If they haven't, then normal contractual rules in relation to amending contracts will apply, and employers could change contractual terms of incoming employees in the normal way. This will, of course, be open to challenge if you've previously announced that there's been a TUPE transfer, so you would need to be careful if you're going to rely on that argument when changing terms and conditions. Employers could also consider ring-fencing the transferred employees. This might be particularly useful if incoming employers are in a situation where there's a disparity in pay between men and women, and they might need to have to demonstrate that TUPE is the reason for the differences in pay rather than reasons based on sex. Employers could also identify a reason for making the changes to the terms and conditions which is not related to the transfer, as we just covered, an ETO reason. Employers could also transfer an employee to a different job and create new terms for them. They might also try to seek to settle risk associated with changes to employment terms under settlement agreements. And there's also the dismissal and re-engagement to consider. And this might be useful for employers who need more certainty around the change. But there is a whole separate government code of practice on that. So you need to look at that if those are the steps that you'd want to follow. If, however, changing or protecting employment terms via a route already mentioned isn't designed for a particular reason, employers often consider harmonising incoming employees' terms regardless. And we're often asked, how long do you have to wait before you harmonise the incoming employees' terms and conditions following a TUPE transfer? And first of all, you need to be clear that harmonising terms is generally not going to be valid because, as we've covered, under TUPE, there is a restriction on changing terms and conditions if the sole or principal reason for the change is a TUPE transfer. So the length of time that passes after a transfer doesn't actually change that position. But length of time might help to a certain extent because the longer you are away from a transfer, it makes it look less likely that the transfer is the reason for the change. And it also becomes less likely that people connect the transfer with the change if enough time has passed. So what is the risk if you're going to harmonise terms? Well, any harmonised terms would be void if the principal reason for the change is a TUPE transfer. And so the terms will be unenforceable if challenged. And then there are also the usual risks of changing terms and conditions where employees don't agree with the changes. For example, employees could react at the time that the employer is trying to implement a change, and they could bring claims, and they could decide if they should decide to resign on the back of the proposed changes, they could claim constructive unfair dismissal. Sometimes, which is more difficult for an employer, I think, is where employees may not actually bring a claim straight away, but they may carry on working but make it clear that they don't accept the changes. The practical difficulty here is that the employer may forget that there's an issue until it becomes relevant. And I'm thinking particularly if you've got a change in redundancy terms or restrictive covenants, because they're not going to take effect straight away, like a change in holiday entitlement or working hours. But then at the point is that the employer wants to make redundancies or enforce those restrictive covenants, which could be years down the line, the employee could then take issue at that point and bring a claim. In terms of practical tips for harmonisation, realistically, if you're offering terms to transferring employees which are better than their existing terms, the employer likely has nothing to be concerned about because employees are unlikely to complain if the changes are better. Another option where there's a mixed bag of changes to implement or that the employer wants to implement, another option would be to offer a package of changes. For example, giving the employee something good like a salary increase in exchange for losing something or making their terms worse. You should be aware that even if you're giving a package of good and bad changes, this could still carry risks of complaints and claims. But you might be able to get those employees on board with the negative changes by making it clear that by challenging any negative changes later on, this would revoke the employee's right to positive changes. So that might reduce the risk of claims and complaints. So all in all, when it comes to incoming employers and they're dealing with a workforce on mixed terms, whether the incoming employer decides to find a valid ETO reason for a contract change, asks employees to sign settlement agreements to cover off risk associated with changes, or whether employers simply decide to take the risk and harmonise terms, whatever the next steps they should decide upon, employers should take a pause before implementing any changes and consider how the changes will be received by the workforce and assess the potential risk before making changes. And if in doubt, we'd recommend that employers take advice. I'd now hand you back to Hannah, who's going to deliver our final section.
Thank you, Jasmine. So the final practical problem that we wanted to address today involves that difficult situation for an incoming employer where you inherit poor performing employees. This might be the reason why the outgoing supplier has lost a contract in the first place. At their worst, they can impact the incoming employer's ability to ensure a smooth transition and maintain productivity. Unfortunately, you can't just refuse to take them just because they're a poor performer. You can't pick and choose who has the right to transfer if they're assigned for TUPE purposes. So what can you do to try to manage the situation? So looking at a few suggested steps to consider. So if we're before the transfer, first of all, if you can, it's important for the incoming employer to try to find out about any underperforming employees if they can. Information provided about the transferring employees by the outgoing employer, so employee liability information, or there may be additional information provided under the contract, or the client may give you a heads up, could all be very useful here. So under ELI in particular, disciplinary and grievance information from the last 2 years might show up any ongoing or previous issues or disciplinary sanctions for performance. You might also receive some information about persistent absence issues. The customer might have already identified issues about the level of service they're receiving, as I've mentioned, and that's the reason why they want to exit the current supplier. And that may be due to existing performance issues with certain individuals, and this is how it's come to light. So there may have been complaints made against a particular individual, for example, where you have a client-facing role, such as a receptionist, or generally the supplier might not be meeting overall KPIs in the contract. If the customer has already flagged an issue, they might have already started a process to deal with these. So, for example, they may have asked the supplier to remove an individual off the service, possibly even to dismiss them. They may have required them to take some action by using rights they have under the contract. But if nothing has been done yet to try to manage the situation, it might be possible to ask the client to use some of those rights to liaise and coordinate with the outgoing employer to try and manage that situation before the transfer. Where there are known performance issues and you as the incoming employer will be taking on the staff, it might be possible for you to agree some contractual cost protection from the customer in negotiations. If they want you to take on that poor performing service and turn it around, you might agree that you'll manage the employees post-transfer, but you need some indemnity protection against any costs or risks if the situation might have to end in dismissal, for example, or claims. Any indemnity protection will be a matter of commercial negotiation. But as a supplier, you really need to be aware of this because you need to manage the extra costs of carrying out performance improvement plans, for example, while delivering the service and making sure that you meet your own KPIs. Don't forget that if the parties do agree to exclude one particular individual from the transfer, or if they've been dismissed, this in itself won't remove their protection under TUPE, and they could still have a claim against the incoming employer. Even if they've been redeployed onto another contract by the outgoing employer, as I've mentioned earlier, there can still be a risk that they seek to unpick that and argue later that they should have transferred. So, as the incoming employer, it's important to ensure that you're protected against all claims by contractual indemnity protections from the customer or another contractual way of apportioning risk. So following the transfer then, of course, an incoming employer might not find out about performance issues until afterwards, until it's too late. You might have some warranty protection about the employee information on the basis that it's full and accurate. Warranties are less likely, of course, in a service provision change. You could also perhaps rely on your protection under Regulation 12 if full employee liability information has not been provided. Maybe the outgoing employer hasn't given you details of previous disciplinary sanctions for poor performance. But the protection here is limited. It's £500 per employee as a general rule. And you would need to show that the failure to provide the information caused the loss, not just that there was a performance issue that you didn't know about. So, of course, it's important on any transfer to assess performance quickly, proactively start to manage this from the transfer date as soon as possible, making sure that you're working in line with your company procedures or any policies and procedures that have come across with the transferring employees. It's always helpful to have clear communication so that you can make sure that employees understand and know the expectations and the performance standards that they need to work to. They need to be able to understand their roles and responsibilities and also what performance metrics you're going to measure them against. So as part of this, as an incoming employer, you're going to be reviewing any employee records that are provided by the outgoing employer. These should contain details about previous performance reviews, might provide a useful insight into the employee's work quality, productivity, any areas that need improvement or training needs so that you can start to implement those. If the employee has disciplinary warnings or is subject to an ongoing disciplinary process, these would be continued under the transfer. The incoming employer is effectively going to step into the shoes of the previous employer. But as a note of caution here, although technically you can step into their shoes, there might be practical problems in taking over an ongoing process or relying on a previous warning as an incoming employer. You still need to make sure that you've got all the relevant details, you've got sufficient evidence, know exactly what's gone on in ongoing processes to successfully continue them, and also make sure you've got enough of the context and background if you want to rely and treat previous disciplinary sanctions as cumulative. You might also inherit some details about training and development records undertaken by the employees that could show what their skill levels are, any gaps that might affect their performance. But of course, that's in a perfect world, you're going to inherit full employee records. Adequate records might not have been kept, processes might not have been started, which is why we've got this poor performance issue in the first place. So ultimately, if you've got a poor performer, what can you do? Can the incoming employer dismiss them? If you've managed to negotiate contractual indemnity protection or other cost protection from the customer as part of the commercial deal, which covers subsequent dismissals, then you'll have protection against the costs of any dismissal and any connected claims. If these protections are in place, do make sure that you know exactly what the terms are. Make sure that you follow any required procedure so you don't risk falling outside of that protection. If you don't have a contractual indemnity, some employees may still be in their probationary period or have less than 2 years service, and that would mean it's much easier at the moment to dismiss poor performers. Of course, employees still currently need 2 years service to claim unfair dismissal, but as we know from the government's changes that they're proposing, from next year this is going to change. And so it's going to be a day one right that employees can claim unfair dismissal. And it's also important to remember at the same time that employees have other protections now from day one anyway, such as discrimination, and that those rights could be triggered if the employee is dismissed and they haven't been treated fairly. If the employees do have unfair dismissal rights, then in the normal way, a fair process would need to be followed. So the employer would need to give training and support to help the transferred employees adapt to the new environment and meet performance expectations. As a final takeaway here, it's important for a successful integration of transferring employees into an existing workforce that the employer is seen to behave fairly and consistently with all employees. You need to ensure that policies are followed. You need to make sure that all issues are managed appropriately. And you can't be seen to be targeting the transferring employees deliberately, because any dismissal, if they can claim that's by reason of a transfer, that again will be automatically unfair. So thank you. I now want to pass back to Jasmine for the wrap up.
Thanks, Hannah. And thank you all for joining us today. That concludes our session and we hope you found it useful. Just a quick reminder, we have our on-demand webinars for the TUPE Club sessions on our website, so you can revisit this one if you want to, or if there are other topics you're interested in, you'll likely find another helpful webinar on our website too. There will also be a questionnaire that pops up at the end of this webinar, and we'd be really appreciative if you could take some time to fill those questions out for us. The invitation for our next TUPE Club session will circulate shortly. And so in the meantime, if you have any TUPE questions, please don't hesitate to contact us or anyone else in the team at Gowling. Thank you.